Hello everyone, it's Nav here from LoanSub again. I run a online mortgage management platform which enables everyone to get a better home loan for life. And today again we have Alex from Atlas Lawyers. He's a gun solicitor based on the Gold Coast, specializing on everything property. Alex, how are you?
Good, thanks for having me again, Nav.
Thank you for being with me. Now today's topic is terminating contract when purchasing a property. Now it's a big one, so I'll let you get started and let's educate some people.
Okay, well again, I'll give this precursor that I'm talking about contracts, more specifically maybe an REIQ contract in Queensland. So different states, different laws. I'm focusing on terminating property contracts in Queensland. Okay, well, the Queensland conveyancing process, now it's a little bit different procedure if you compare it to places like New South Wales or Victoria and how the conveyancing process works. We have this conditional period, and in our previous talks we talked about things like building and pest inspection that comes after the signed contract. So that's one condition, that you can terminate your contract based on that and receive, as a buyer, receive your full deposit back as if the contract never happened. But it's quite important. You can't just, it's not like a cooling off period, and I've discussed that in a previous podcast or video, where you in cooling off, you can terminate for whatever reason. For building and pest, it's specific. For you need to terminate based on something building related or pest related, but you need to take reasonable effort. So, and that is set in the terms of the contract and also in case law, that you have to act honestly and reasonably. What you need to do is you have to arrange for a certified building and pest inspector. Usually, the date for building and pest would be maybe 7 or 14 days from the contract date. When I speak to my clients for the first time, as buyers, I tell them, is that arranged? I make sure that that's arranged, and not only that it's arranged, that they tell their inspectors to provide the report as soon as possible. Because it's also in terms of the contract that you must, if you're going to terminate, you must provide a report to the seller solicitor and base your reasons on why you're terminating based on building and pest. So we can't just say, we want to terminate based on building and pest, and you haven't arranged for a certified building or pest inspector and haven't received and provided a report for the seller. So that's very important, and that ties in with acting honestly and reasonably. Now, what does reasonably mean? I'll get into that a little bit later. Here's one important one: terminating contract based on the finance condition. The finance condition, to be frank, is a very loose condition. There's a very low threshold. Still, it's not like a cooling off period where you can terminate based on any reason possible. The finance condition is subject to satisfactory finance. And once again, in the terms of the contract, and we're talking about an REIQ contract, but any other contract usually would have the similar clause that the buyer and seller must act reasonably and honestly. You can't just sit on your hands and say, I didn't get finance, but not retain a lender, not speak to someone, not get any quotes, because that can go against you. So you have to take honest efforts to obtain finance. That being said, now is it obtaining finance? Finance can be very, very subjective in whether, what happens if you do get finance and it's not the percentage points that you want to pay? What happens if you do get finance and you're getting less than what you would have, but you still have enough to settle? Can you terminate on that? And again, this is a little bit of a gray area. But the more important thing is you have to act honestly and reasonably. Now, every law student is going to tell you this mythical, reasonable person test can go either way. What does it mean? It's all dependent on circumstances and situations specific to the case, specific to the person. But this is why the threshold becomes lower for if you want to terminate based on finance condition.
So
because
if you go on.
If you want to terminate based on finance, I think I lost my train of thought on that. Go ahead. Yeah.
So in that case, I'll ask you a question, and sorry to interrupt. So would you say when signing a contract to purchase a property, it would be wise for a buyer to stipulate on the contract that as part of the finance clause, a lender of the buyer's choice, finance approval from a lender of the buyer's choice? Because technically, if the buyer goes to the seller and says, I couldn't get finance, and there wasn't anything stipulated, like which financier, the seller could actually go, hey, I can arrange private finance for you. There you go. You got finance. Yeah,
technically, you're right. And if someone comes to me before they sign a contract, then it's absolutely, I say, be as specific as possible. The more specific as a buyer you put that, subject to lender of the buyer's choice and to buyer's satisfaction. That's also a good one to put in there, because that then makes it a subjective test. And subjectively, one person's risk of borrowing may be different than the other, which makes it hard to contest in court for a buyer against the buyer that's terminating a contract. So it secures you as a buyer. The more specific you are, the more secure. I highly recommend, putting something more specific in there in that finance clause. So good point, Nav. Yeah, absolutely.
Brilliant.
Now, what I've been talking about, and if you were paying attention to my previous video, please watch our previous videos. There's the conditional period. Now, what if you want to terminate once everything's unconditional? There's a huge difference now. If you want to terminate, I mean, if you can't go through with a contract, you can't go through with the contract. But if it's unconditional, you can be very likely on the hook for significant legal costs, especially with the extent of what a property contract would the amount of money that you're dealing with. So this is, and it's always specific to the contract, to the person, but definitely you want to talk to your solicitor, or a solicitor, to give you legal advice if you ever want to terminate based on an unconditional period. I don't anticipate you getting away without paying any penalty, but it definitely would require some strict and strategic negotiations if you do need to terminate a contract through the unconditional phase to discuss between the buyer and seller solicitors. So that is much more difficult and requires much more legal skill involved when you want to do that. But it can happen. There are still certain warranties. For example, if you're buying a part of a body corporate, doesn't matter if it's conditional or unconditional. If there are things that weren't disclosed or various other reasons, there could be ways that you can terminate and escape without penalty, frankly, but definitely requires a very, very close eyes to make sure that you can do that.
Okay, brilliant.
And that's it for me. That's, again, REIQ contract can be very specific based on special conditions. So if there are any additional specific special conditions that you may have in the contract, that may also allow you to terminate it. That might be mutually beneficial for both parties.
All right, brilliant. Thanks, Alex. You've been insightful again when it comes to conveyancing and what property buyers should be aware of. And thank you for joining us. It's Nav here from LoanSub, and we spend the afternoon with Alex from Atlas Lawyers. Till next time, see ya.